martinis. I think I might have to do the same over here.
Well, we've got a great turnout today. 386 people were registered last time I checked. We've got a bunch logging in now, over 100 with us today. Thank you for joining us. We're going to be live streaming on YouTube, which will also expand our audience. So really, really good turnout. Really appreciate everybody spending their lunch with us today. And what do you think, Daphne? Top of the hour? Are we ready to make a start?
Yeah, let's do it. Let's make a start. So welcome everyone to Family Law Now virtual event series. Thank you for joining us today for Voice of the Child. This presentation has been accredited by the Law Society of Ontario and contains 1 hour of professionalism content. Today, the panel will discuss preparing and delivering Voice of the Child reports, private versus OCL judicial interviews, the weight, treatment by counsel, parents, and judges, screening, the child's right to counsel, challenging VOC reports, and they'll mention case law throughout as well. As always, we encourage you to participate in the polls and use the Q&A feature throughout the event, and the panel will do their best to answer your questions as they come in. The resources mentioned today will be included in the show notes, which you will receive via email tomorrow. So stay tuned for that. And without further ado, let's welcome our panel. So we have with us today Russell Alexander, Golan Uren, Jarrett Johnston, Jonathan Painter, and Judy Louis. Russell Alexander is the founder of Russell Alexander Collaborative Family Lawyers. With over 25 years of experience, Russell has written 4 books on separation and divorce and is a fully trained collaborative practice lawyer. Golan Uren is an associate family lawyer and a certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. Golan has extensive experience in representing clients in negotiation agreements as well as trial work. He also has experience in negotiating with the authorities to advance a client's interests and has represented clients at various levels of court, including on appeals. Jonathan Painter is a registered social worker and psychotherapist who works in the family law system, completing parenting plan assessments, Voice of the Child reports, family mediation, and collaborative family law in private practice. He also provides psychotherapy such as cognitive behavioral therapy, family therapy, and couples counseling for children and adults. Jonathan is on the board of directors of the Ontario Association for Family Mediation, holding the executive position as treasurer of the board, and is on the board of Collaborative Practice Durham Region. Jarrett Johnston is a partner at Gemmell Johnston Jeffries PC, where he practices primarily in family law, specializing in litigation, collaborative, traditional settlement work. Jarrett also offers services in wills and estates and real estate. Jarrett is the president of the Kawartha Lakes Victoria Halliburton Law Association, and an executive on the board for the Kawartha Collaborative Practice. He's acted as a director for the Children's Services Council and spoken at several provincial, national, and international collaborative conferences and seminars. Jarrett is passionate about getting his clients the best result possible with the least amount of financial, mental, and emotional damage, whether in the boardroom or the courtroom. And last but not least, we have Judy Louis, is a registered psychotherapist, registered marriage and family therapist, and the clinical director of Your Story Counseling Services. She also co-authored a chapter in the first edition of an intersectional approach to sex therapy, centering the lives of Indigenous, racialized, and people of color. She is a committee member with the Anti-Racism Advocacy Group at the Canadian Counseling and Psychotherapy Association where she helps organize community events and panels on racial trauma and advocacy. In 2004, Judy was chosen as one of 3 RBC Canadian Women Entrepreneur Awards micro business finalists. And I will now hand things over to Russell Alexander to get started with the presentation.
Thank you for those kind words, Daphne. Let's throw a couple slides up. We've got lots of questions coming in. Jonathan, there's one about special needs I'm going to ask you during the first poll. And maybe put in the Q&A where you're watching us from. It's always fun to see who's coming in from where. So Jonathan teased this a little bit in the opening remarks. We have collaborative practice training coming up in Ottawa. Jonathan and I will be there along with Carrie Heinzel and Brian Galbraith in person, April 7 to 11. It's maybe our only in-person event this year. We also have 5 seats available remaining for if you want to log on virtually to get your collaborative practice training. So look for that. Next Wednesday, this is the 19th, we are going to be having a discussion with David McDermott Scott. He's one of my coaches. He teaches me how to market law firms. If you want to learn how to market your practice, sign in for that. It's free. David's a great guy. He's got a new book out. We're going to be talking about tips and tricks for lawyers in marketing, including how to use AI to market. So look for that coming up. That's next Wednesday if you want to join us. And let's get at it. Voice of the child. Jarrett, what are we talking about? Legislation. What gives rise to what is a voice of a child, and why are we talking about it today?
Yeah, Voice of the Child, or VOC report, is generally required by the courts these days. The amendments in 2021 put a little bit more emphasis on the professionals ascertaining the current views and preferences of the child. Section 24 of the Children's Law Reform Act, it's one of the subcategories that the court is supposed to garner in terms of going through checking off all the boxes of what's best overall for the children. There's a little bit more emphasis these days on bringing the voice of the child to the forefront when decisions are being made for the children. So in terms of legislation, that's sort of where it stems from, Russ. But of course, you know, when we're working in our collaborative files, when we're working on our out-of-court settlement files, we often find a way to bring the voice of the child to that process as well.
All right, let's run our first poll. And this poll is, how often is the Voice of the Child report obtained? We'll give everybody a few minutes to register their answers. Jonathan, can we go to that question that just came in? Can you just give us a short summary and what your take is on it?
Yeah, it's a really great question, and it is always more challenging to bring the voice of the child into the process when the child is nonverbal. So they could be too young to be verbal, you know, like a 1 or a 2-year-old, or maybe they have some kind of condition or disability that limits their ability to communicate at an age-appropriate rate. So the idea is to get context. You know, how does the child function in one home versus the other? What's the school telling us about, you know, how the child's functioning? Do they have any therapists that can, you know, like a physiotherapist or occupational therapist, or some kind of support person who can give us some insight into what the best plan for the child is, or what their preferences might be. So you wouldn't necessarily handle that through a voice of the child process. Maybe you would want to do like a section 30 or an OCL section 112 instead. But there are always ways of bringing the voice of the child into the process, even if the child's not verbal.
Okay, let's see our poll results, and we're going to explain what section 30 and 112 is throughout this process if you're not familiar with that. So let's see what our audience is thinking. Is obtained in every dispute, 7%. Only when one of the parents is asking, 3%. Every case if the judge orders it, 11%. Every case is if ordered and it's accepted by the OCL, 79%. Sherry, you're an OCL lawyer. Why wouldn't the OCL accept an appointment from a judge? I assume it's a resource argument.
Yes. Was that directed to me, Russ?
Yeah.
Yes, yeah. Normally it is unfortunately just budgetary restrictions. Office of the Children's Lawyer doesn't usually give any more specifics than that. When they reject a file, it's upsetting for the parents, it's upsetting for the judges sitting in family court because it's a great service.
Yeah.
But it's usually a budgetary restriction. Sometimes it's other factors. Sometimes if CAS has been heavily involved or is currently involved, sometimes if they feel that there are factors involved in the scenario that would skew or weigh down the importance of their involvement or how effective they can be. So sometimes it is other reasons and other factors, including domestic violence and CAS involvement, but normally it just comes down to budget, the time of the year that you requested them.
That's a good point. You can even ask your case management judge to ask the OCL to reconsider the issue. And 3 months later, they may have the funds available. So that's a great point. All right, Jonathan, who prepares the Voice of the Child report? Let's talk about qualifications and training and how's it done?
Yeah, so you would want someone who has a lot of experience working and interviewing children, because interviewing children is a very particular skill set. It's not the same as interviewing adults. You have to know, how to ask questions properly, because children are very easily led. You need to understand their age and stage of development, because children's brains work very differently from adult brains. So you would want someone who has, A, experience working with children and interviewing them, but B, training on things like child development and proper child interview techniques. There are courses you can take if you're interested through the Ontario Association for Family Mediation. OAFM has a course periodically to teach the skills, but generally you would want someone who has that background. They should be probably a social worker or a psychotherapist or a psychologist who has experience working with children. You generally want people with a master's degree, although there are some exceptions. I know some very, very talented Voice of the Child providers who have a Bachelor of Social Work instead of a master's. I would trust them to do just as good a job as someone with a master's, but generally you're looking for someone with a master's degree. I think if you're a lawyer or a family law professional and you're considering this, it's okay to ask for the Voice of the Child professional's CV to find out what is their experience, and what is their training on this. Generally, I would say the vast majority of people who do this work are social workers. A lot of them work for the Office of the Children's Lawyer. That's a big part of what the Office of the Children's Lawyer does, but many of them aren't. And also remember that this process can happen not just in court. Now, it's very common in court. I think the statistic I read somewhere was about 21% of family law cases have a Voice of the Child as well, because it can be a really good way of resolving conflict, because parents will often say, well, I know the kids want this. And the other parent says, well, no, I know the kids want this. And then the Voice of the Child can bring that neutral point of view to find out what the children really want. So it's very popular. And so Voice of the Child is usually performed by a social worker, sometimes psychologist, sometimes psychotherapist. And I don't know, do you folks know of any lawyers who do this work as well? I don't know any who do, but I know that there are some lawyers who do Section 30s. So, but yeah, generally, you want to make sure that the person has a lot of experience and the right qualifications. I don't know, Judy, do you have anything to add to that?
Yeah, I think my experience, because I am not someone who writes voice of the VOCs myself, I usually collaborate with the person who has been hired on to do that. And so I've already established quite a connection either with the family and family therapy, or I've been working with the child for quite some time. And so in that case, I think I saw a question about, don't you have to build trust with children before you know how they're feeling? That kind of addresses those pieces, because my work is in providing reports, providing my observations and context, in having already worked several months, several years with the family, and that can provide a more richer context than perhaps some of the shorter interviews that VOC has. So in a lot of ways, there's depending on the situation at hand, if there are already folks that are working with a psychotherapist, usually it is most of the time social workers I've worked with. I'm collaborating with them alongside teachers and other adults, other physiotherapists, speech therapists to help with supporting that material.
Let's go to our next poll. But Jonathan, there are some tells with these kids, right? If little Johnny says, I want 45% parenting time with my dad, like, come on. Kids don't talk that way.
Yeah.
But
Yeah, exactly. Yeah. Or yeah, I want a week on, week off schedule with the exchange being on Friday at 6:30 p.m. That's
Yeah.
not the kind of way a child's brain
I
works,
need at
and they're
least
not gonna come up with
40%
those
time with
details.
this parent. Yeah.
Yeah, exactly. Yeah.
Well, we got give our audience, thank you everybody for sending in your questions. They're fantastic. Please keep sending them in and participating with the polls. We'll give everybody a moment for this one. How much does the Voice of the Child report cost? Here's one. Jarrett, a question came in. So is the OCL just appointing another lawyer to the file?
Good question. The OCL, it's actually, once the request is made from the court, the OCL has the discretion whether to do a section 112 or section 89. One is appointing a clinician to do an investigation and report back to the court in terms of best interest analysis. The other one is actually appointing a lawyer to represent and advocate for the child. So it's the child's lawyer. Both same are government funded, free of charge, but there's a difference. And to the question, yes, it's an additional lawyer in the court proceeding, but the lawyer's job is to specifically advocate to the court through the lens of what the views and preferences of the child are. And back, 40 years ago, the lawyers that worked at the OCL had a little bit more discretion in taking a best interest analysis and bringing that to court. They're really handcuffed now in terms of you're really can only advocate what the child is consistently and independently expressing as their wish. But to Russell's point, that's hard to do sometimes.
Yeah, and that kind of makes sense, right? Because it's the judge's job to determine best interests. So if we have the OCL lawyer advocating their own personal opinion on it, that's not helping the court, right? The court wants to know what the child's thinking. Is that right?
Yeah, exactly. Yeah, that lawyer's job is to bring their voice to court through a neutral lens.
What if you don't agree with the voice?
Then you have to dispute it.
No. What if the lawyer who's appointed as OCL doesn't agree with what the kid's saying?
Yeah, those are tough ones. I had those.
This is what little Johnny's telling me?
Yeah, exactly. I've had those. Those are very tough files. When I was working for the Children's Lawyer's Office, I had a few of those where I didn't think it was best what the child was giving me instructions to advocate to the judge. But that's where back in the day, you could kind of get around that a little bit by weighing in with your own sort of opinion. Now you're pretty handcuffed. You have to, whether you agree with it or disagree with it, you need to advocate. They're your client. So you have to advocate for those wishes, even if you disagree with them.
I guess at the end of the day, you're scratching your head on that one, thinking, why the hell am I doing this job? But you're not subject to cross-examination by the parties. You just provide the information to the court.
Yeah, sometimes we will have a clinical assist. The lawyer can ask for a clinical assist, and then the clinical assist will do an affidavit, and they'll provide evidence to the court. They can be cross-examined, but the lawyer appointed to bring the voice, you're right, cannot be. So
just flesh that out. Let's assume our audience doesn't know anything. What's a clinical assist? What are we talking about here?
So if you're appointed by the Office of the Children's Lawyer to be the child's lawyer, and you're in a tough situation, you're in a situation where it's high conflict, parents don't agree, your advocacy is being challenged, you can then ask the Office of the Children's Lawyer to extend the purse strings a little bit and give you what's called a clinical assist, who's a social worker that works for the Office of the Children's Lawyer's Office as well, a clinician, and they will assist the lawyer. So now the child has not only a lawyer, but also has clinical social worker also assisting that lawyer in advocating for the child's views and preferences at court, which is nice to have for the child.
Are they required to produce a report?
No, no, they're not. So same goes. If it's a high conflict situation, oftentimes the clinical assist will sort of be forced into doing an affidavit. But normally at the offset, their job is to help the lawyer garner the wishes and preferences and advocate that. They're not strictly required to provide a written report of any kind.
Right.
Yeah.
Really helpful. Sorry, you want to jump in on this conversation going?
Yeah, I was just thinking that without that report, we have an admissibility issue that may rise as a result of that. Because if the lawyer is just advocating for the child, trying to say this is the information I received, now we're dealing with a statement out of court. We're dealing with all kind of an admissibility issues. And when we have a report, it's sometimes at least we're looking at it as an expert report, and then the expert is subject to cross-examination, which may give the court a better assessment of the authenticity, the independence of the child's information that was that the lawyer is advocating for. But it's not. I think it would always be better to have the voice of the child report, also for argument on the admissibility issues and ability to cross-examine the person who did the report or investigation. I think that's a very important aspect of it, because it's not just hearing the child and letting the court, but how would the court assess that information is truly independent and has not been influenced, etc.
Yeah,
That's
it's
just
really good insight going. Yeah.
I agree.
Got a little sidetracked there. We were doing a poll, but I think this conversation's adding a lot of value. So let's see what our poll results are. Cost of the report, no cost, 58%, both parties share, or they share proportionate, 50-50, depends on the number of kids, 3 to 10 grand. Judge decides and by who. Well, I think there's no cost, right, Jared? Like, this is great value that the court's giving these parents.
Yeah, the only thing I'll say to that is they get rejected frequently. So, by going the private route, the timeliness of it, and it's a big factor.
That's our next subject. Private versus OCL, and maybe we'll talk a little bit about judicial interviews. But okay, so we've gone to court. The judge says no, or the court says the government says we're not appointing. And there's a lot of strategy as counsel you can deploy during an OCL appointment. If you want to potentially avoid a motion for parenting and you have an OCL investigation, the court's going to wait. And it could take several months. Maybe you don't have the resources to do it privately. You want a public appointment. So a lot of strategy you want to think about your client's goals and interests, what's going to be the best outcome for this family. But private reports, what are we talking about here, Jared?
Yeah, well, we're going to defer to Jonathan a lot during this, but we ask for private VOC or voice of the child reports frequently in our out of court and collaborative files, especially. They can be timely. They can be, as you've already mentioned, a lot of times the parents won't agree what color the sky is.
Right.
So they're certainly not going to agree what the children's wishes are. Having that VOC report can settle a case entirely. So even though there's a cost to it, it's an excellent way to move matters forward and get an independent and objective. And to Golan's point, something in writing, something in black and white, something that's tangible, that we can use, unless the clients have agreed to seal it or that it can't be used in court or something like that. But either way, the private VOC reports are an excellent way to go.
I'm a fan. I'm a fan because think about it. We can get somebody like Jonathan or another family professional involved within days or a week, as opposed to waiting 60 days to see if the OCL is going to. If your clients have the resources, go private. Get somebody in there immediately to triage whatever the issues are. Sorry, Golan, I think I cut you off there.
No, I'm sorry. I was going to jump in because I was in favor of the private one for the reason that Jared just mentioned, that there could be a situation, especially in, if the parties wants to mediate or want to try and settle things before they go to court for a motion or any adversarial proceeding. What a The advantage is that, for example, Jonathan can tell us that if the parties agree that it can keep parts of the interview confidential because the child doesn't want to, release that information. He doesn't want to, have a retaliation by one of the parents because he's saying one thing against the other, etc. That gives the comfort to the child that he's able to actually do that without risking anything. And like Jared said, the timeliness and the availability, I think overall the comfort of a child with a private assessment is can go a long way and not would not be as intimidating as the other
Okay,
the other
we're going to
ways.
get to the nuts and bolts and Jonathan in a moment, but also think about this in collaborative settings, right? And I think these are great for older children, a teenager saying there's a fractured relationship or they want to make a move. And if you're in a collaborative setting, you get a voice of the child report. I've had meetings where, the family professional said had to tell one parent, little Johnny doesn't want to spend any time with you. And it's heartbreaking, right? But the parent recognizes this is the child's voice. It's not coming from the other parent. And usually the case settles. So even though it's gut-wrenching news to get, you're not going through a 2-year hearing and a 5-day trial. But one quick question before I jump over to you, to Jonathan on the how. Jared, have you ever done, or Golan, have you ever seen judicial interviews conducted or been part of that?
Golan, do you want to
No,
go first?
in my experience, I've never seen a judge that jumping on the opportunity to interview a child. I don't think they want it. I think they would shy away from it as much as possible. Although I heard of occasions that it happened, maybe more likely in the past than in these days.
Jared?
Yeah, and I've had one. And that judge in particular was one of the lawyers who spearheaded the office of the children's lawyer.
Oh, yeah.
So he was particularly well trained to interview children. He liked to do it, and he'd sometimes order our clients to bring the child to court on a whim. But other than that, Judge, I know it's very seldom, and most judges will decline, even if there's a lawyer really pushing for it. Usually we defer to a OCL or a private VOC.
There's trends in family law, right? I had the one with the same judge. I'm going to tell a story in a moment, but when the judges went to their judges conference and they started talking about voice of the child reports, that was the flavor of the day. Every case was getting a voice of the child. It's like, it seemed like 9 out of 10 cases, and now we kind of scale it back. But the one I had, do I have your permission to tell a quick story?
Absolutely.
Who are you asking? Of course.
It's your show.
Same judge. I'm not naming names. We're in Peterborough court. It was a mobility issue. Mom was out west. Kids were with dad and mom's parents in Peterborough. And she tried to commence an action in Alberta, and then there's a whole jurisdiction issue and all the rest of it. And mom hadn't seen the little Johnny. I'm just making that name up. But the case is real. Hadn't seen little Johnny for a while. So the judge goes to me, Mr. Alexander, where's the child? Child's at home. Or I think it was summertime at home. And he goes, okay, I'm ordering your client to bring the child, the two children, like I think they're 8 and 10 or 8 and 11, to bring the children to court. I think, what? I go, Your Honor, there's no OCL. There's, I can get the grandparents to bring. After lunch, I want the kids here, right? I go, this is insane. And so the kids are shitting their pants, excuse my language. They're sitting in the front pew. They have no idea what's going on. And the judge goes to the other lawyer who's representing mom from Alberta, says, I'm going to do a judicial interview today. We're there on a case conference or a return of a motion, right? And I'm
can
not
see
too
that.
sure what to think of this. I think it's going to go well for my client because little Johnny doesn't want to go to Alberta. All he's known was Peterborough. Mom had moved out to Alberta. Mom's counsel thankfully said no. So I didn't have to look like the person not agreeing to this crazy process. And so now he's all in a miff, and tries to call the judge in Alberta, and the judge in Alberta doesn't take his call. He gets screened. And then he goes, I'm ordering an access visit right now to take place in courtroom 3, and my CSO is going to supervise it. This is craziness, right? And I guess the CSO is probably reporting back to the judge how the visit went anyway. So that was the end of my judicial interview story, and I still shake my head about it. But let's get back to the subject at hand. The how, Jonathan, talk about OCL reports. Where are the interviews conducted? How many? How is it delivered? Oral versus written? What do we need to know?
Yeah, and Judy, jump in as you see fit. So my process, and it might be a little different depending on the professional you're working with, but my process is to first interview the parents individually, find out what the issues are, what their perspective is. A couple of people have asked questions about, parent alienation and parent influence. That's one of the ways that I screen for that, is by, talking to the parents and finding out what their perspective is on the situation. And then I will have at least 2 interviews with the children, one when their parent A brings them in, and one when parent B brings them in. That's to make sure that you're getting different perspectives, and you're assessing the child's comments for consistency. Like, did the comments change dramatically when they were with dad versus with mom? And also you as the professional providing the report, you want to appear to be fair and balanced to the parents, because if they think you're biased, then the whole process is a waste of time. And so making sure that one interview happens at mom's house and one at dad's, or depending on the genders of the parents, dividing it up that way helps actually maintain that neutrality, but also be showing the parents that you're neutral, and the court as well. I will usually have 2 interviews with each child, and I try not to interview children together. Like, if there's siblings, I try to interview them separately. Now, there are some cases where there's siblings really want to be together, and in that rare instance, I'll assess the situation and decide whether that's appropriate. And the first part of the interview with the child is about consent. You want to make sure that the children have your consent. So you want to explain the process very thoroughly, but in child friendly language, and then ask them questions about it to make sure that they understand what you're asking them. And then the next part of my interview is about rapport building and trust building. And so I'll ask them more fun questions. Where do you go to school? Tell me about your friends. What do you like to do for fun? What's your favorite kind of food? Or what kind of food do you hate? Just ask them any interesting, how many pets they have. Like, just get some interesting information about them. And then once that process is done, I'll kind of move into the more serious topics. And then once I've interviewed the children, I'll have a disclosure meeting with the parents to say, hey, this is what the parents, this is what the children have said, and offer the parents an opportunity to resolve, to reach an agreement on at least the parenting stuff. And then I'll provide a written report for the parents and the lawyers and the judge as well. And that report is usually filed in court, in the continuing record. So that's kind of my process. Judy, do you have anything to add to that? Or
sorry, Jonathan, if the parents settle,
yeah,
when you deliver an oral report, do you still file a written report with the court?
Yeah,
but it's shorter, I assume.
Not really. For a section 30, if I was doing a full section 30, I would do a abbreviated report if we reach a settlement, but I don't do that for Voice of the Child. The Voice of the Child reports aren't usually very long. They're only, I don't know, 4 to 8 pages, whereas a section 30 is a monster for me because I have problems keeping my writing short. So mine are usually, 25 to 35 pages long. So it's a short report. And the advantage of it, one of the advantages of an voice of the child, is that they're so much faster than a section 30. A section 30 can take months and months and months. I can knock out a voice of the child within a couple of weeks.
Okay.
If all the, schedules align nicely.
You want to add to that, Judy?
Yeah, I mean, I think Jonathan covered everything. My experience is more in supporting folks that are writing the VOC or lawyers that are working with the family through this. But maybe one thing I'll add to this is like part of the process is in that report writing or in my report writing is using neutral language. We're not leading the child to answer in a certain way. We're really looking at the context of what is their everyday lives and their feelings about it. And a lot of it is rapport building, like Jonathan said, using a lot of therapeutic techniques to really bring some emotional and psychological safety to the children, which is part of bringing that consent. And I think Golan highlighted of, children knowing that what is being said here is safe for them to share, and then and making sure that those questions are open-ended. But we're also looking for really other like using trauma-informed approaches as well to kind of look at are there concerns around safety? Are there concerns around abuse, neglect? That's a big part of what I'm looking for as well when working with children here.
All right.
Yeah, well said, Judy. And one thing I'll just add that you kind of triggered when you said that is I forgot to talk about one of the last pieces of consent that I do with the kids is after I've had my conversation with them the second time, I'll go through my notes and say, is it okay to include this stuff in a report to the court? Because they ultimately get to decide what goes in that report or not. I'm not the decision maker here. The court's not the decision maker. The lawyers aren't. It's the child. And so I'll go through and say, hey, you told me this. Is it okay to include that information in the report? And that way the child really feels comfortable that they are in charge, that they can trust you, that if there's something that they want to leave out, then you will. Now, having said that, just keep in mind that if there are safety concerns, if you learn about abuse or neglect, that's part of the consent process, explaining to the child, if I learn about these things, by law, I have to go and tell, the Children's Aid Society or the police or whatever about, child abuse or neglect. So that they're fully aware and know that that is one of my responsibilities. So the consent process is one of the most important pieces to this. And, a lot of the questions in the question and answer were about, how do you get a child to open up? How do you get them to trust you? How do you prevent children from hiding their feelings? And in my experience, kids are almost always really happy to talk to a neutral professional who will listen to them, and they often feel like no one's listened to them in this process to date. Their parents are fighting all the time and have their own opinions, and the lawyers and judges aren't really asking the child what's going on. So I find in the vast majority of these files that children are more than happy to talk to me about it.
Yeah, Golan?
Yeah, I wanted to add that the expectation from a voice of the child report is not for an opinion. So that is something that we're not expecting either Jonathan or Judy to provide us. What we want to see is, so the assessment of the report could be on a more objective lines of a consistency and independence of the views and preferences of the child. So maybe that's the reason that the analysis is not, or the report is not as long, because really I'm expecting just a verbatim, expressions or statements from the child. One of the things that you just said here, Jonathan, I'm kind of now thinking that if you're keeping things away from me because the child told you not to include it, I'm kind of worried about that.
Here
I'd
comes
like to see
the
that.
warrior. Golan's coming out swinging. Look out.
Do you want to put me on the stand and cross-examine me, Golan?
No, I would imagine that would be fair in a private assessment for the parties to resolve things in a mediation and otherwise. But I would expect that in a court process, I'm not sure we have that liberty of just picking and choosing what we can include in the statement of the child if he said that, right? If he told you so. I'm not saying that you're supposed to break all trusts or anything like that, but there's got to be the fairness to the parties in terms of assessing the voice of the child, the statement that the child is given may lie on that particular portion that is kept out. And that may be, the trigger for perhaps the alienation, you have to keep a secret, you have to not say that to anybody. So that's I think that we have to differentiate between, for the reasons for the voice of the child, for what purpose are we using it, whether it's going to go to trial or whether it's going to go for a mediation or something that's being done privately outside of court. I think that is the kind of the limitations that we have to consider. But definitely opinions are not expected to be provided by the professionals doing the work here.
I think Golan wants to cross-examine little Johnny. We've got lots of great questions and comments coming in. A couple of questions about the training that we're offering, the collaborative practice training, some questions about the marketing conference. Daphne put links to those in the chat box, so you'll find those there. A great comment came in that it's important that you remind the child that he or she is not the decision maker, right, Jonathan? Their voice
That's right.
isn't necessarily going to carry the day. Another question came in.
We've all met those kids that they want to eat candy and stay up all night and aren't going to make decisions in their own best interests. And so there is it's really important in the consent process to help the
Need to
child
manage
understand,
that
well,
expectation.
we want your opinion, but it's not, you're not the decision maker here.
Yeah. And another great question coming in. How does a party request an OCL? I think, well, I'll tell you my experience and then we'll get the correct answer from Jarrett. Usually you do it with your case management judge if you're in a superior court that's being case managed. Sometimes you might be able to get one through a 14B motion at the front end. That's usually an exception, but Jared, are they still, remember there's a period of time where they always wanted to talk about clinical issues before we get into an OCL. And you'd come out, you'd create some clinical issues to get the appointment, but is that still something case management judges are looking for, or how does somebody get one of these appointments?
No, exactly. It's still pretty much that way. The judges are looking to counsel and the clients to sort of inform them in terms of what they can put in the request that gets sent to the Office of the Children's Lawyer. So most judges in Ontario are a big advocate if they see the merit of it. So they'll do their best when they send the request to make sure they hit the boxes in there, which will convince the Office of the Children's Lawyer to take a serious look at it. So the case management judges are still doing it that way. They're looking for counsel to give them the nuts and bolts to put in the request to be sent to the Office of the Children's Lawyer. They're looking for both sides to consent to it. You touched on this, Russ. But either party could bring a motion for a Section 112 or Section 89 on their own volition. You don't have to have the other parent's consent. If you bring that motion, chances are, like most files in family court, or if there is some conflict or there's a disparity of what each parent thinks is best for the child, generally speaking, our judges are going to order it because it's more information on the plate. And just like the VOCs or a more thorough best interest investigation, they're going to want more information to make a better decision.
Senior counsel is informing us in the Q&A that you do not need clinical issues for a voice of the child, which is correct. Thank you for that. Anybody want to add on to this before we move off of the how? This is very thorough discussion, though. Thank you, guys.
I was just thinking, if I may, Russ, in terms of how to get the order for the voice of the child. You mentioned the 14B. That's one of the options. It's still available. It's if everybody's on consent, it's even better. It can also come from a judge's perspective. Normally, in a case conference, that's the first time that the parties are together and the conflict is kind of more a clearer in the sense of, how big the disparity in the dispute is, and then the request can be made during a case conference, and it could also be, like I said, the judge can decide on it if they think it's necessary for them to assist the parties in resolving the matter. So, in terms of how you get the order for the voice of the child, I think that's the best way is 14B and then the case conference request. I also find that the OCL are not really resisting a voice of the child as much as you're talking about section 30 and 112. The investigations are more time consuming and more expensive in terms of budgetary. And when it comes to voice of the child, they can produce that, within days. It happens that we did that within a week's time, it was produced.
Yeah. And we're not talking about simple disputes like whether little Johnny's going to get dropped off Sunday night or Monday at school. It has to be something more than that, right, Jarrett?
Yeah, exactly. That's going to be part of their decision-making process, whether they order it or not. I have had the odd judge reject the idea and refuse to order a VOC report. That's typically in cases where there's a lot of evidence of alienation already existing, if they've been in court for a long time, and you hear judges saying, well, why would I order that? I already know what this child's going to say. I already know what's going to come back to the court. In those types of situations, they may be looking to order reconciliation therapy before they do a VOC report, or they may be looking to do a more thorough section 30 assessment before they simply will order the VOC.
Right. Okay, so we've got the report now. What weight do we give it? Sean, Golan, what do we do with this thing when we get the report?
Well, that's falls exactly to the point that Jared just made there in terms of if one of the parties alleges alienation, for example. How do we deal with that? So at the end of the day, it comes to weight. In my view, the voice of the child has to be obtained without discrimination, whether there is allegation of alienation or not. Ultimately, the judge will have to make the decision and decide whether he actually formed the opinion, or the child formed the opinion of his views and preferences independently. And if he didn't, then the voice of the child is really the way that he's going to give it is maybe nothing. But at least, all the context has to be there. The circumstances of how the interviews, came about and how it unfolded. This information we're going to get from the expert, from Jonathan or from Judy and the others, and that would allow us to either critique the report. So once I receive a report like that, I may go to Jonathan and say, tell me what has gone wrong here in this interview. Maybe too many leading questions, maybe the circumstances around them, who was in the room, etc. I'd like to see the notes. All of these things have to be explored to decide whether a cross-examination of the person who did the report is required, and whether we have to establish, what's the underlying, whose opinion is it, or whose views we're actually hearing here, whether the child is just parroting the parent, or whether it's actually an independent view. So you have the option of critiquing the report, cross-examination of the expert, and other evidence that you may want to call for corroborating allegations of alienation, or a different opinion that may have biased the views of the child. That's at the end of the day, it's the way to be given, and that's up to the judge. It's not delegated to the professional that does the voice of the child.
My take is if it's done properly, or if there's not too much mischief, certainly some of these parents are going to be trying to coach little Johnny to say or do whatever. My assessment would be it's going to be driven by the maturity of the child, right? We've got very immature 15-year-olds and very mature 10-year-olds. and to some degree, the age of the child. That would be my take. You know, if you've got an older child that's pretty consistent in his or her views, the court's going to give that some weight. What's your take, Jonathan? I mean, Jarrett?
Yeah, I agree. Absolutely. The maturity of the child is focused on a lot in the courts. And to your point, Russ, that's not necessarily dependent on age. You know, if we, as professionals in this field, if we had a dime for every time someone asks, is 12 the age that their wishes trump everything else? You know, I've had cases where I've had 9-year-olds that were very articulate, very smart, top of their class, mature, and the court gave their view and their preference more weight than anything else combined, right? And then I've had 14-year-olds where the judges said, you know what, I'm not going to give that VOC much weight because, goal in my experience, I have had VOCs where the professional will say, I didn't experience anything that would suggest alienation in the VOC report. So that is a bit of an opinion there. And I've had the contrary. I've had VOCs where the professional will put in a quote from the child that makes it quite obvious that there was some coaching going on before the VOC. And then that may lead to other things being ordered, right? We may get into more thorough assessments, but absolutely, Russ, to your point, age, maturity, the way the child can articulate. When I used to do them, it was amazing. You know, sometimes the child would change the way they spoke from one interview to the next. Jonathan, Judy have an extremely difficult job and they do an excellent job at it, but I don't envy them because it's a very, very tough thing to do.
Great questions coming in. I want to hit some of these questions just because I think they're right on point. Voice of the Child report done a year and a half ago. Can a new one be requested? Why not get an updated opinion, right? Wait, or view.
Absolutely.
Long time.
Especially if circumstances have changed.
Yeah.
I think, you know, a new partner has come in on the scene, or the parents have moved to a new town, or changed schools or whatever. Like,
a lot can happen in a year and a half, right?
Just by virtue of the age and maturity, that alone can change things.
Okay, another
I have
great
a case
question.
now where they did two Voice of the Childs, and then in a section 30 after, because there were still more questions. They
still wanted to fight. Okay, you know, we sometimes live in a bubble and speak our own language. Let's gear it down a little bit. We've got a question I think is pretty decent. Who wants to take this one on? Can you summarize the differences between the Section 30, Section 89, and the Section 112? Sounds like we're in a huddle calling a football player or passing play here, but Jarrett or Jonathan, you guys want to take a kick at this?
I'm happy.
Sure. Go ahead, Jarrett.
Okay, so real simple, and then Jonathan can jump in. But a Section 112 is done by the Office of the Children's Lawyer. It's ordered by the court, and it's free. The government pays for it. Section 30 assessments are very similar. The assessor's trying to ascertain the best interests and makes recommendations in written form. Jonathan mentioned it earlier. Some of his Section 30 assessment reports can be 30, 40 pages long. They're a much more in-depth investigation. Jonathan's gathering collateral information, possibly school records, medical records, background checks. A Section 89 is also through the Office of the Children's Lawyer, and that's appointing a lawyer for the child. And remember, I mentioned this earlier, when you ask for a Section 89 appointment, the Office of the Children's Lawyer doesn't necessarily have to do that. They can order a Section 112 instead. So you have to remember that if you're in family court. But again, the lawyer appointed for the child, their job is to advocate the views and preferences of the child. They can't use their own opinion. They can't say, I know they only are saying they want to go, little Johnny only wants to go to dad's because he says he'll buy him a pony on the weekends. We can't tell the judge our personal opinion. We're handcuffed. We have to advocate for those wishes and preferences. So when you're considering which one to ask for, keep that in mind.
I'm kind of smiling because this exactly is what happens, right? One parent tries to sway another parent. Jonathan, did you want to add to Jarrett's distinction between those different sections?
No, Jarrett, you did a great job. The only thing I would add is there's also something called a Section 90 of the Child, Youth, and Family Services Act, which is similar to a Section 30, but it's for child welfare cases.
All right. So great discussion. A few more topics we're going to cover off and one more poll question, and we'll take some more Q&A. Lots of Q&A coming in. Please keep sending them. They're
Great
fantastic questions. We're answering a lot, even though we're not announcing them, but we're typing out answers. So please keep sending them in. Screening, parental and other influences. Judy, you want to take the lead on this one?
Yeah, I can definitely do that. Screening for parental influences, I think for me, the biggest piece is around that interview that Jonathan mentioned, of the individual interview we have with the parents. In there, looking for I'm looking for kind of if there are high conflict, if there's emotional distress for the parents, if there's already kind of some parent influence in trying to sway my point of view around the other person. I try to keep, I make it very clear, like, you know, I tend to ask the same questions for each parent and let them know that my job is to hear their part, not to hear what they think about what the other parent is saying or doing. And then I'm also taking into, I think, cultural or religious or other kind of identity aspects around context of the family, so that these are also things that allow me to better understand the day-to-day operations for the home, as well as gives me context when I am speaking to the child around what does that day-to-day look like, and are there kind of, you know, are the points that the child is making, you know, click with what the parents are sharing as well.
Jonathan, you want to add to that?
Yeah, so remember that the whole field of psychology exists because people behave in patterns. And so you can look for those patterns in the comments the parents make or the comments that the children make. And, you know, especially when you're dealing with kind of younger children in the kind of 9, 10, 11 age, they're pretty naive about how they sound to you. So they might have a pseudo maturity, and like you said earlier, Russ, they might be including comments that clearly didn't come from them, but they won't be aware that it sounds weird because of their age and stage of development. So they might be saying, yeah, I really want to spend 40% of my time with dad, and not kind of realize that it is
Kids talk that way, don't
clearly, yeah, really on the school ground, they're like, oh, I really want to spend 40% of my time with my dad. So he
What
doesn't have to provide
percentage
support
time
to
do
their
you spend with your
buddies.
mother? Yeah.
That's
Yeah.
before they studied
So-
about percentages.
But I would say, as a general rule, if you really suspect there's a severe or even mediumly severe case of parental alienation, a voice of the child's probably not the best approach. I would suggest you go for a full Section 30 or Section 112. And that way it'll be a much more global assessment of the family system, and we'll have recommendations about treatment for parental alienation if it's present.
All right, let's go to our next poll. It's been a while and we love hearing from our audience. So at what age should the court have to consider the voice of the child? So you've heard our opinions, but let's see what you think about this. And I'm going to go to another audience question that came in advance. Thank you for sending your questions in ahead of time. Can a parent ask the child be heard in person? So, you know, that sounds pretty
It can ask.
conflictual. What do you think, Roland?
It can ask doesn't mean that it's going to be approved.
Okay.
Very unlikely.
Let's say you do ask.
It's very unlikely that, like we spoke about it before, whether a judge will you know, entertain an interview with a child, regardless of the age. I think at this point, they just won't. I don't think they're most of them. I don't think are qualified to interview children. Maybe they are, but nevertheless, I think they will defer to professionals to do it. And I think that would be. It's also, I think, the sense of impartiality that you know, they don't want to influence that. If it goes to trial and they do the interview of the child, I don't think that would be always a fair process. Maybe it would be.
I think this question was saying, okay, well, Jonathan's reported this, or Jarrett's reported this is the voice of the child. Can we challenge that by saying, I want to hear from little Johnny. I want to hear little Johnny say it. So, I guess the question is procedural fairness to the parent to, I don't think that would be in the best interest of the child to expose him or her to that kind of conflict.
Absolutely. And that's one of the reasons they don't do that, right? It's part of the confidentiality and comfort that we try to give a child,
Right.
while letting him participate and encouraging and giving them the sense of having some control over what's happening in their lives. But nevertheless, we don't want to expose them to this kind of adversarial proceedings.
Great question. Jarrett, what's your take on this one?
Yeah, I've had this come up on where I see this come up and that request made a lot is there's already a VOC. So the court's already aware of what the child's wishes are. And then a little bit of time goes by. And then let's say the child has changed their views and preferences. And the parent who wants that change in opinion from the child to be expressed to the court may ask for another VOC report or may ask for something, and the other parent says no. So then they're kind of caught in this difficult position. It's like, well, I know little Johnny's views have changed, and the court won't order another VOC, or they won't order, and that's when you get those parents saying, I just, I want little Johnny to be able to speak because his voice, he's changed his opinion. So you get difficult.
I just bought him a pony. The views changed, but
yeah, exactly. Yeah, exactly.
Judy, Jonathan, you want to chip in on any of this? You have a take on it?
No, I think Golan and Jarrett covered everything there.
All right, let's see what our results are. So what age should the court consider it? Younger ages, 1 to 30% up to 12, that's right. 12 to 15, 27%, all of the above, none of the above. When they start looking after the
That's great.
Is there a sweet spot? Like, what are you guys seeing in terms of, and girls, in terms of when the court really would want to hear something? It would be like 10 to 14, 10 to 15. Where's the sweet spot?
So that question is different from at what age should the court consider a voice of the child report. That question is at what age should they consider the children's perspective, and that's all ages. Like, you've always got to bring the voice of the child in, even if they're newborns and they've only been born a week ago, you still have to bring the voice of the child in. Now, obviously, a newborn's not going to tell you their preference, but that's where Section 30 can help, decide, which home the, child, or what parenting schedule works best for that child. Generally in Ontario, I find that voice of the child usually start about 7. If you get kids younger than 7, developmentally, they're just not going to be able to provide you with much useful information. Before 7, they still engage in magical thinking. They don't really have a good, clear understanding of time. Like, they can't tell if something happened yesterday or 3 months ago, and they really don't have an understanding at all of psychology and human behavior and parental behavior. So it's just, you're not getting very much useful information before the age of 7. And even 7, I would find, like, some kids would be able to manage it, some kids wouldn't, depending on their maturity level. What's your take on that, Judy? What do you think?
Yeah, I mean, I think that's kind of generally what I've seen and what I have. Most of the support I give to the folks that are writing the voice of the child or any other documentation like the Section 30, that would probably be about the same for me.
Yeah.
We got an audience member saying in Manitoba they do them with children 12 or older. They're no longer called voice of child reports out there. They're called brief consultation reports. Section 30, Jarrett, what are we looking at in terms of costs, roughly?
Yeah, I'll just ballpark, but yeah, obviously it can range probably anywhere from 8,000 to 50,000, right? In terms of a fulsome Section 30 report. we're lucky that we have people like Jonathan in our area that do them. I know certain areas of Ontario, they're more seldom. But yeah, that's probably the range. A lot of times the parents are splitting the cost. So if it's a $12,000 Section 30 assessment, you're each going to be expected to pay $6,000 each. And then sometimes, depending how deep, I'll defer to Jonathan. But if we're getting into a psychological assessment as well, and we're getting deeper into more layers to the onion for the assessment, they can be looking at added cost, obviously. Yeah.
Does that feel about right,
Yeah,
Jonathan,
no,
those
that's true.
numbers?
Yeah, that's right. Yeah, I would say Jared kind of hit the nail on the head. I would love to see one of these $50,000 reports. Like, is it printed on gold paper? Like, do you get a first class ticket to go meet with the, do you get a massage while you're being interviewed, kind of thing? That would be the gold standard. Yeah, but Jarrett, you're right. There is a shortage of people doing this work, and so I often will travel all over to do them. I did one a couple of years ago in Kincardine. I've done one in Nunavut. I do them in kind of the north and east all the time. So, if any of the audience members are interested in starting this work, there are courses you can take through the AFCC and the OAFM to learn the skills. I know the OCL offers their own training for their clinical investigators, which is what they call their assessors. Yeah, I think that's a good average range. And keep in mind too, if you pick someone like me who's a social worker, or someone like Judy who's a psychotherapist, you can often claim some of the fees on your benefits and get at least a partial discount for them.
Can you do this by Zoom, or is it in person?
So I always do the child interviews for a Voice of the Child in person if I can manage it, unless they're really, really far away. I just feel like the rapport building is a little bit easier when you have a child in your office. You have a little bit more control of the setting. For Section 30s, I would do parent interviews online if they're far away, and then do a home visit in person and interviews with the kids in person. And I'll kind of like rent a hotel in Kincardine for a couple of nights. And the first night I'll do this first day I'll do the home visits to both parents, and then I'll do the interviews with the kids afterwards. So that's kind of how I organize things. But I know some people just do them all online, and then some people exclusively do them in person. So it's kind of a choose your own adventure.
Judy, are you remote or in person when you do your work?
I really highly recommend in person. That connection is a lot harder to do virtually, especially for younger folks. If there's a issue of distance, then I'm okay generally with seeing parents virtually, but especially younger, like under 12, I highly recommend in person.
Okay. And another question came in, lots of questions. Thank you, everybody. Can anyone share more about clinical assist and how that works with OCL? So, Jared, what are we talking about when we use that language, clinical assist?
Yeah, they important to know they don't have to do it, right? You can request. So usually it comes from either the children's lawyer themselves, or one of the other lawyers for the parents may suggest it. But it's a request made basically internally, or it can be suggested by your case management judge. But you have to request it from the office of the children's lawyer. They would have to see the merit in it, because it's extra money that they're spending from the government purse on that added professional. But yeah, they're excellent. They're integral to the process, and they have, Jonathan and Judy are talking about how hard it is to develop that rapport. Well, they have that same training. And they have that ability to develop the rapport, and then they help articulate the wishes and the preferences to the court. And as we talked about and Golan mentioned earlier, a lot of times they'll end up doing an affidavit. They'll end up doing putting things to writing that can then be cross-examined and challenged and assessed and pulled apart by the court. So they can do things that the lawyer doesn't do, because we're the child's lawyer. So we're not going to be a witness. We're not going to be putting ourselves on the stand, whereas I can have a clinical assist interview with me alongside the child, taking notes the whole time, and then that clinician could potentially be cross-examined on their evidence because they've interviewed and they've ascertained the wishes as well. So they'll have to testify towards the consistency, the independence, and the strength of the child's views and preferences, which is something very important when the Office of the Children's Lawyer is doing that. That has to be demonstrated to the court.
Another important tool in the judge's judicial toolbox. All right, the child's right to counsel. Golan, you want to take the lead on this one for us?
Well, I think the same way that we spoke about the right of the child to be heard, it stems from the UN Convention on the right of the child that Canada has ratified. Later on, we have incorporated that into legislation. In Ontario, we have the Children Law Reform Act provides for a process for hearing of the child, but also for that the child is entitled to his independent legal advice. That again is also a role that if we bring an application or a motion to appoint a counsel, and many times you hear that in child protection cases, that you find that the appointments are more frequent in these in that area. Again, it can be done through the OCL. It can be done privately. The advocacy, Jared just spoke about it. It's the same way that he was speaking about the role of counsel to advise the child as to his rights, as to his consequences, make the recommendations. You know, a child does not necessarily will go along with that. He should be able to give instructions to counsel. If not, then you know, that's a different scenario when maybe counsel is not an appropriate appointment if a child cannot give instructions to counsel, and therefore the advocacy will be on the part of counsel based on his recommendation, and nothing you know, no real input from the child. But in many times you will find that counsel is appointed for children if we find that they need advocacy in protection cases, as I said, or in general family cases. Yep, that's generally the sphere of that idea of having representation. Just like adults have the right to have their own independent legal advice, they're no different.
All right, so little Johnny's giving us his voice. We've got the report. We've got maybe an affidavit, maybe not. How do we challenge this? Let's say our client doesn't like what little Johnny's saying. Jarrett, how do you go about challenging a voice of the child report?
Yeah, you can do it in writing. That's typically how it's done, and you need to do it right away. So you can challenge maybe things that they missed. You can challenge perhaps the strength. I kind of mentioned these words. The catchwords are the independence, the strength, the consistency, and usually it's done in writing right away. If you're going to challenge a VOC, you should do it right away.
Golan, how would?
Yeah, so we have the time frame for filing the dispute to the voice of the child, and then once you come to a hearing and you have a trial on the issue, you can cross-examine the professional that did the report, and like I think I mentioned that before, critique the report with other professionals. I did that with Jonathan on one of my cases, and you present that as part of your as part of the credibility, not only of the process, but the, you know, to cast doubt on the you know, the authenticity or the independence of that views and preference of the child. just like any other witness that you want to discredit and try to make a case for your client to suggest that the views should be considered otherwise, or the inference should be contrary to what has been reported to the judge. At the end of the day, we're asking a judge to not delegate their responsibility of decision making, or the best interest of the child, neither to the child nor to the professional who made the interview. It's about the voice, not the choice, as we say, of the child. They should not be making the choices there.
Sounds like a bumper sticker.
Yeah.
Let's talk quickly on case law. We usually try to wrap these things up at around 1:15. Want to thank all our audience members for participating. So cases, the one I like, and we'll include a schedule in the show notes so you guys can get the reference afterwards. ILVCR 2021 Ontario Superior Court decision, when judges make determinations as to the weight to give to a child's stated preferences. There's a number of factors that they look at. We've talked about all of them here this afternoon: age, maturity, clarity, context, consistency, potential alienation or influence, the strength of the expressed view, and the thinking behind it. So that's what the judge is going to be looking for when he or she receives one of these reports. And again, like we mentioned today, this is just one of many factors the court's going to consider, but it could be a weighty one, depending on if these factors are met and the judge is satisfied, and other considerations. Any case law you want to dip into, Golan?
One that I thought was kind of a good overview is the Medjak and Medjak case. The citation of that is 2019 ONSC 2019, and it also makes a reference to a Supreme Court of Canada case of Manitoba versus C, and it goes over the right of the child to be heard, and the difference in the weight and the weight and preferences, that you would give to a voice of the child report. And I think it would be a good overview and read if somebody's interested.
Jared, any favorite cases you like to read at nighttime?
Oh, there's lots of them. No, just off of Golan's case. There's lots of reported cases that flow from that, and I had one in particular where during COVID, a 10-year-old didn't want to be vaccinated. So if any of our audience members are bored, take a look at some of those vaccination cases, because they're touching on this. You have some reported cases where a 10-year-old was very mature, very articulate, and could explain through a professional why they didn't want to be vaccinated, versus some where you might have had a 13-year-old who really didn't have good reasons why they didn't want to be vaccinated. So sometimes the court will put much more weight on the child's ability to express their voice, and it's not necessarily exactly dependent on them being 12 or 10 or 14. So the cases all touch on that. It really comes down to that maturity.
Yeah, those facts cases were tough. Parents are passionate on one side or the other. So I'm going to get some final thoughts and wrap this up. We did get questions about the case citations. We're going to include those in the show notes. So after today's event, you'll get a survey. Please fill it out and tell us how we did. And we'll also send you references to the case law that we just mentioned. Once again, you can see Jonathan in person in Ottawa, collaborative practice training. Links on the screen and in the chat. Next week, next Wednesday, Marketing Your Law Firm with David McDermott Scott, one of my marketing coaches. Learn his secrets and how to use AI to market. And let's just do a quick roundtable, final thoughts or takeaways. Judy, it was great having you this afternoon. First time presenter for this forum. You want to go first for us, Judy?
Yeah, thank you for having me. I mean, I think this is a really important conversation to have, especially the divorce is hard already, especially on the children, and being able to use something like the VOC and having kind of really it shortens the time of pain and suffering for all involved. And yeah, thank you for having me, and hopefully some of my thoughts and some of my experiences helps the audience here.
It's been a pleasure. Golan?
Yeah, firstly, I think firstly it was fun. Thank you guys for doing this. And it's a very practical area of law that I think it can be utilized very well for resolving cases quicker. The amount of money that's being spent even on a private retainer for a voice of the child will be a better spent than spending it on lengthy litigation that would cost 10 times more than that. Thank you again for having us or having me as well. It's
Yeah,
a pleasure.
pleasure. Always wonderful having you on, Golan. You're a real staple. And Jonathan, you're always here. I appreciate all your support. Any final thoughts on Voice of the Child?
Yeah, I just think that it's a really great process to help expedite your court case and quickly resolve parenting issues. Obviously, it's not going to resolve the support calculations or equalization or post-separation adjustments, those kinds of things, but it's a process that works. It's used a lot, and I would encourage anyone who's going through this, wanting to help their clients, consider referring them for a voice of the child.
Yeah, and I've worked with you before, Jonathan. You're doing great work. Keep it up. And Jarrett Johnson, actually, people may not know, took time out of his winter holiday to join us today. So thank you for your insights, Jarrett. You've done this work for over a dozen years that I know of. Any final thoughts from?
Yeah, thanks for having me, Russ. It was a pleasure as always. One final takeaway for me, remember, you can do these voice of child reports out of court. You can do them in the collaborative process, mediation, traditional settlement. You don't have to go to court and get it ordered. Mom and dad can agree. And one thing I found when I'm trying to encourage clients to do it, because it might help resolve the matter, is you can agree that it be sealed. You can agree it just stays between the parents, private, confidential, can't be weaponized against you at court later on. Great way to resolve files and great way to get the children's thoughts and opinions and wishes and preferences on the table. Thanks, Russ. Thanks for having me.
And all our clients ultimately want what's in the best interests. And I'm a fan of these reports. If you're in litigation, it could settle the case super quickly if you do it privately. And in the collaborative setting, we use these reports quite frequently when little Johnny's telling mom one thing and dad something else. So thank you, everybody, for joining us today. Thank our audience for joining us. Thank everybody who's watching us live on YouTube. This has been a great presentation. Case law is coming in the show notes. Look for the CP training, and we'll see hopefully a bunch of you online next week when we talk about marketing. So have a great afternoon, everybody.
Take care. Back to your margarita, Jared.
And our debrief.
Yes.